Okay, apparently that
personally.
just hasn't been entered yet. What was the date of service?
Date of service. Let me double check that. I'm working on low bandwidth over here in the courthouse. Hold on.
Oh, okay.
Let's see. Sir. Okay.
I think I may have seen something that said February 27th. Does that sound correct?
Yes, that does sound correct.
Okay.
It may have actually been earlier than that.
But got filed on the 27th?
Yes, Your Honor.
Okay. All right. This is a motion for contempt and a motion for attorney's fees filed by the respondent in the case, Christian Myrtle. Ms. Thomas, you received service of that motion and you're ready to proceed?
Yes, Your Honor.
All right. This is a situation where things are reversed here, and the movant here is the respondent, so they get to go first, and then you will get your opportunity to respond. Okay.
Okay.
All right, Ms. Steinhaus, if you will, I don't know if you plan to swear in your client or how you plan to proceed, but I'll let you go ahead and take care of your case.
Okay. So we filed this motion for contempt in, I believe, October was the first time that we filed it in. At that point, the TPO, the temporary protective order, was granted by this court in August. The court had given both parties until, I believe, August 26th to register with Nia's place for a safe exchange of their minor child. And at that point, in the temporary protective order, there would be no changes to visitation, no changes to the already decided upon custody agreement, their time-sharing order out of the state of Florida. That was the court that made that decision. From August until the middle of November, Mr. Mertiel was not able to see his child. Petitioner withheld visitation rights from Mr. Mertiel. He was not able to visit his child. She also neglected to register with Nia's place, which was per, I believe, let me just find in my notes. I believe it was section 27. Yeah, subsection 27 of the temporary protective order. Mr. Mertiel had went ahead and registered with that. At that point, petitioner also communicated with their shared minor child not to go with Mr. Mertiel should he come to the school to pick her up, which was also in violation of subsection 16. So the only option that Mr. Mertiel had.
Excuse me, what do you mean by, was it an open-ended as far as where he could pick up and that sort of thing? Or maybe I misheard you.
So with subsection 16 and 27 in the temporary protective order, he was to pick up their minor child from either her middle school or from.
Okay, you may have said that and I missed it, but
I also speak really quickly and I apologize for that. Or from Nia's place. So the petitioner had also communicated with Utopian Academy for the Arts, which I put in, I believe, as Exhibit A or custody agreement.
Okay. We're losing you, Steinhaus. You were breaking up due to bandwidth issues.
Okay, can you hear me now?
Yes.
Okay. Petitioner had communicated with Utopian Academy for the Arts, which was minor child's middle school, that they were not to release the child to Christian Mertiel, which is her father. We have a letter from both the middle school and from Nia's place. She is not registered with them per the order. And
as of today, you mean?
As of today, she still has not registered with Nia's place. And as we approach springtime and summertime, I think the biggest fear for the respondent is that she will go back to violating the actual agreement in terms of custody come summertime when the child is no longer in school. Is the only option, right, to do an exchange with school.
We lost a few of your words there.
Can
you repeat whatever you said regarding summertime, after summertime?
So our concern at this point, because the only option for the exchange of the minor child is through school, that come summertime, because there has been no registration with Nia's place, there will not be an exchange available.
Okay. All right. Anything else?
We're asking for attorney's fees in this case under OCGA 1913.6 and 1913.4. So it is a remedial opportunity as of now. Mr. Mertiel has been in and out of court in regards to this matter since petitioner originally applied for the application. She has been in violation of this order. He has done everything he needed to do. He completed his family violence intervention program as of yesterday. He went through all 24 weeks. He's done absolutely everything that he needed to do on his end and only wishes for the abidance of the actual order itself and for to maintain his visitation with his child.
I hadn't had much chance to look at the file in the court's Odyssey system, but what was the date of the 12-month TPO?
I can actually pull that up.
I could too, but I thought you might have it at your fingertips.
I should. I would have everything open. I believe.
Was it sometime in August of?
I believe it was August 5th, and then it was signed August 8th.
Okay. Was I the issuing judge in that case, or?
No, it was Judge Edgerton.
Okay. All right. And I believe you indicated you're asking for attorney's fees?
Yes, Your Honor.
What do you wish to present that at this time or later?
I don't know. I think in terms of remedial sort of remedy that can be done under a family violence order, you continuing to either A, hold the party in contempt, but also in terms of remedying the situation with Mertiel. I said he's been in court on numerous occasions for this case alone. He's had a really hard time with the visitation and not being able to see his minor child. He's had to hire not only my counsel again for this motion in contempt, but also more counsel down in Florida to file.
Okay, we lost her.
Yes, sir. I will look for her to log back in.
Oh, I'm back.
All right, Ms. Steinhaus, we lost you there for a minute. Last I heard was hiring counsel in Florida.
Yeah, so he's had to go to extreme lengths at this point, is my argument. He's had to hire counsel in Florida to have her abide by the by the visiting order that they already had ordered down there in order to hold her in contempt there, and same here. So he's continued to have to hire attorneys for this case.
What was the order in Florida? Was this like a legitimation order, as we would call it here in Georgia, or was this a divorce decree?
It was not a divorce decree. The parties have never been married. Okay. It would be, it all had to do with custody.
Okay. All right. And are you asking for anything specific?
The attorney's fees would be the flat fee that I charged Mr. Mertiel for this contempt motion, which I believe are market rate. They're actually below market rate from what I've seen.
Okay, well, I don't know what that is, so if you'll tell me what you're
asking.
Yeah,
I charged Mr. Mertiel $1,500 for this hearing.
Okay.
And for all the work that I put into it up until this point.
Okay. All right, thank you.
Thank you.
All right. Ms. Thomas, do you wish to speak on this?
Yes, sir.
I'm going to go ahead and place you under oath as well, so that if there's any cross-examinations or cross-examination or questions that need to be asked, they can do so. Please raise your right hand. Do you swear or affirm testimony you're about to give in matter pending will be the truth, the whole truth, nothing but the truth, under penalty of perjury?
Yes, Your Honor.
All right, you may proceed.
In regards to Nia's place, I have registered with them as of January 9th. I did fail to register by August 26th. As of today, we have not had a need to go through Nia's place. But the main reason why I hadn't registered timely was because I had just started another job and I couldn't get the time off to go in to complete it. But I have completed the registration as of January 9th. I would also like to note, as when I did register with Nia's place, they advised that they would be sending the court a certificate of completion or something of that nature. At that time, I went January 9th. They also advised me that Mr. Martil did not comply by August 26th. He actually completed his orientation with Nia's place after that deadline as well. But nevertheless, I am in compliance at this point. But we had not had any, we didn't need to go through Nia's place as of today because all of the exchanges that Mr. Martil has had with our child has been through him picking her up from school.
When did that begin?
I mean, that's something that we have been doing. I think the first visit that he had with her was in November.
Okay.
Outline, and that was because he was supposed to have her for fall break for our county, which started on October 10th. October 10th. But we were out of town. My uncle passed away, and I was the one who took care of all of his arrangements as far as his cremation and things and such. So I actually left and went to Florida prior to the fall break starting, and my children came with me. So when we returned, I reached out through my attorney for Florida to see if Mr. Martil would be interested in making up his time in November, which he did, which that ran from our daughter was with him from November 4th until November 28th. So I did allow him to make up time. Plus I gave a little extra because, it was like a touch and go situation when it comes to our custody order. Prior to us going back, we were communicating just fine. We were exchanging and deviating from our actual court order. So we were exchanging. He was actually being able to have time sharing with our daughter outside of our court order because we were just going whenever she wanted to go with her dad ask, and I would allow that to happen. That was prior to us getting this TPO. So he, prior to that, and since we had received our court order in 2017, he had never, the 1 September incident that the attorney is referring to where the school said that he couldn't get her, my daughter didn't want to go with him, but nevertheless, I was already at the school. We had a flight to catch. That was Labor Day weekend. My daughter did not want to go with him for that weekend. And honestly, I didn't know that he would be utilizing his first of the month visits because prior to us being in a bad place due to this TPO, he had never utilized the first of the month visit. So it wasn't something that was in the front of my mind, like, okay, she's going with her dad this weekend. So, I didn't know that he was going to get her because, like I said, he had not been utilizing first of the month visits prior to that incident. So it wasn't something that I just knew was going to happen, or I knew that he was going to utilize that time sharing because he had never done it. I mean, he had done it before, but within the last 2 to 3 years, he has not utilized the first of the month visit. So I was unaware that he would be picking or coming to the school, and the choice was up to my daughter, and she didn't want to go.
How old is your daughter?
She's 12.
Okay. 12-year-olds don't decide.
Judge, I'm sorry, Judge. I do apologize. I just received an email that the respondent is here.
Well, yeah.
But the respondent attorney.
Right. They're out the hall, yes.
Oh, okay.
It appears you're out the hall. Are you out there, Ms. Steinhouse?
Okay, maybe she's in the clerk office. Oh, she's back. Okay.
Okay.
Okay, thank you.
Okay, you keep freezing up. Have you been able to hear the testimony, Ms. Steinhouse? You're on mute.
Oh.
Please unmute.
I have.
Okay. It's showing you're muted, but I'm hearing you.
Yeah,
I can't wait till we get back.
I have been able.
Okay.
Yeah, me
All
too.
right. I saw you disappear there, so I just want to make sure you were back and able to hear. Thank you, Ms. Broom. All right, Ms. Thomas,
So, yes,
you can continue, please. Oh, let me ask a question. The Labor Day weekend, that was less than a month after the 12-month TPO had been granted?
Yes.
Okay. All right, go ahead.
So you were saying, well, my daughter was 12. I left the choice up to her as to whether or not she wanted to go. I have been counseled by my attorney that, she can't decide if she wants to go or not. So again, that was something, that we discussed at that time. And that's why I allowed additional time for Mr. Martil to make up, because I'm partially to blame for that situation because my daughter didn't want to go. But again, I didn't know that he would be utilizing his first of the month visit because
hold on a second. I think we may have lost Ms. Steinhouse again, or we lost the video anyway.
Correct.
Oh, she can hear us.
Her audio is suspended right now.
And I think that's what she was trying probably to tell the clerk office. It might just be in a bad area.
She's in the Gap courthouse. Isn't she? Oh, man.
Yeah, the courthouse is not the best place for service.
Well, especially if you're doing it on your phone.
Yeah, we just
At the
lost them.
courthouse.
Yeah.
There's a lot of concrete and steel in there.
You would think that since we've been on Zoom for the past 3 years now, it'll get better, but technology seems to get worse.
Well, if we got to use this technology, you would think we would improve our Wi-Fi band or whatever.
Mm-hmm.
Oh, man. There might be, if it's not raining, they might be better off sitting out in the front of the courthouse.
Log back in.
Okay.
I'm back.
Welcome back. Where are you in the courthouse?
I'm sitting outside 1200D.
You're outside the courthouse?
I'm sitting outside room 1200D.
Oh, okay. I was gonna say if it's not raining, you might be better off on the steps.
Right. Well, I was unfortunately not sent the Zoom link, and I
Okay.
was told that it was in person. So,
All right. Okay. I don't know whether you've heard everything.
So
As
I
soon as you
believe
disappeared, I asked her to stop. So I think you're up to speed.
probably the last thing I heard was that she had spoken with her attorney that a 12-year-old was not able to make decisions
Okay.
about whether to go.
Okay. I think that's where we are.
Okay,
Um,
I'm going to walk towards the front of the courthouse. She can
Okay.
continue her testimony. I just want to make sure that I'm clear.
All right. Is there anything else you wish to say, Ms. Thomas?
Yes. So again, like I said prior, my attorney did inform me that I can't leave that up to her, but it was just one of those situations where I did not, like I said, I did not know that he would be.
Hold on. Ms. Steinhouse's screen is frozen again. I'm not sure if she's hearing us or not. Ms. Steinhouse, can you hear us? Okay, there you are. Okay, you're on.
I can hear you, Your Honor. Just bear with me while I walk on the stairs. Okay, is that better?
For right now, I was just kind of throwing out a suggestion as far as doing it outside. I hope it's not raining or anything. Well, you frozen again. Still frozen.
Oh, can you hear me?
I can hear you at this moment. Yes,
Okay.
it appears that the video, is kind of rough, if you will. It's not going smoothly, but as long as you can hear and we know it's you there, I'd like to go ahead and proceed.
Okay.
All right, Ms. Thomas, you may proceed. You've already covered the issue of the attorney in Florida. Anything else you wish to tell me?
Yeah. So it just kind of sounds as if I was deliberately keeping our child away from her dad. I honestly and truly I wasn't. There were things that came up. Like I said, September. I didn't know that he was now going to start utilizing his first of the month visits because he had not been doing that prior to then. And as far as fall break in October, before fall break started, I had already gone back to Florida because I was the one that was responsible for taking care of the arrangements for my uncle's cremation and his funeral services. So that was why I was gone. I was going from up into maybe like the 16th or the 17th. But nevertheless, I did allow Mr. Martil to
Okay.
make up time. Make
All
up.
right, we don't need to repeat everything. I believe Ms. Steinhouse heard everything.
Okay.
Anything new that you have not already told us?
No.
Okay. All right, Ms. Steinhouse, do you have any questions?
Do you have proof that you've registered with me as place? Because upon phone call with them Monday, we were told that you had not registered yet.
I don't have proof. The only thing that I have is this booklet that they gave me at orientation. I don't. She told me that a certificate of completion would be sent to the courts to let them know that I was in compliance, but I don't have anything. But I did complete orientation January 9th.
Okay. Well, we need to clear that up with me as place. And while I understand that you're saying it was not intentional, we have a letter from the school and from Mia's place, both stating that you hadn't registered with them as of November, which I know that you have admitted to. But the bigger issue is that you communicated with the school saying that he was not allowed to pick up his child.
I have never told the school that he is not allowed to pick up Zaya. They have a court order, so they follow the court order at the school. So I'm not sure where that information is coming from. And Your Honor, I would also like to know, because I didn't get a chance to say this before, we had a hearing on January 25th for our Florida case. None of these things were addressed as far as him not being able to visit with Zaya at that time. We had a hearing for other things in our court case, and none of these things were addressed. But if I were deliberately trying to keep him or not allow Zaya to go with her father, Your Honor, I would have never initiated makeup time. And that wasn't something that my attorney came up to me and said, here, this is what you need to do to make this right. This was something that I suggested. I reached out to my attorney to have the makeup time. So again, it was nothing deliberate.
Ms. Steinhouse?
I mean, I think at this point, my client would like to respond. Martial would like to say a few things.
Okay.
So if I could please your oath.
I probably should. Since Ms. Thomas is pro se, I was more or less doing that kind of as the opening statement, but allowing you to cross-examine as well. So it's still your case to go ahead and proceed with your client.
Okay. So Mr. Martial, would you like to give your recollection of your visitation?
First, please swear him in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand. So can you please give me a recollection of what happened after the temporary protective order in terms of your visitation with your child?
Yes. So after the TPO was granted in August, I'm someone who always do my visitation. It's not never that I'm not going to never do no visitation. So after the order was signed, I was deprived August visitation. I was deprived September visitation, which I had the school write a letter as to why I couldn't pick up our child. Part of the reason why my daughter didn't want to come with me because she's not informed properly by mom on when she's supposed to be with me according to the court order. So if she doesn't know, and we're all from Florida, and it's a trip to go to Florida this weekend, and she doesn't know to come with dad. As a child, she's going to want to go out of town. So I had a letter written from school for September. October, after just having a conversation with our daughter, I was notified that her uncle died. But had Shakar registered for Nia's place in a applicable time that the courts told her to, she could have delivered that message through Nia's place, and I would have, hey, her uncle died, she can go this weekend, and we can find some type of resolution on how to make up time. November, before we got a new court order in January of 2023, I was to exercise every first weekend of each month, which I did faithfully. The first weekend after the TPO that I exercised was the first weekend of November. Shakar did offer makeup time that was later in November, but being that Shakar was I had a current motion for contempt in DeKalb and in West Palm Beach, Florida. I assumed, because she didn't clarify in the writing, that she was offering makeup time for the contempt in Florida and not in DeKalb. So that's not makeup time that went towards what was going on in the cab. That was already before the TPO. I had a contempt motion, and we were just ready, just waiting for that court date to come about. So I had this contempt motion in Florida since November 2019 of she violating the custody agreement.
Ms. Steinhaus, when was your motion filed?
November or October? Was it October?
Yeah,
I believe it was October.
October 2022.
So whose contempt takes precedence? The cab or West Palm Beach?
West Palm Beach, and I believe an agreement in West Palm Beach was made in January, which Ms. Thomas did mention, and now custody has been reorganized at this point to 60% for respondent, 40% for petitioner. So their custody has been changed as of January, has been modified.
Okay.
He now has more custody of the child. He does have primary custody under Florida and Georgia law, but unfortunately, I think our biggest fear again would be that this order would be violated coming the summertime. Because I'm still confused about Nia's place. I don't understand why they would tell us that she had not registered yet.
Okay, with the exception of, sir, hold on. With the exception of the Nia's place portion of paragraph 27, everything else was supposed to just be in compliance with other court orders, as I read it. Is that correct?
Yes, Your Honor.
Okay,
Yes,
so if that court order changed in January in Florida, then whatever those terms are the terms that the parties are supposed to abide by under our order. Correct?
Yes, Your Honor.
With the exception of any exchange or at Nia's place.
Yes,
when,
Your Honor.
when did your client register at Nia's place and do orientation? What are his dates?
It was sometime in September. I had a meeting, an orientation date in August, but I missed it due to time conflicts, and they only do orientations on Monday, so they got me in on the next available Monday was sometime in September.
Okay, so technically neither party complied with the court's order to have it completed by August the 26th, which is something that we've tried to stress in our orders is to give a date, because obviously if you leave it open-ended, then the parties drag their feet sometimes and don't get it done in a timely fashion. So what was the status of in Florida?
Say
Was
that one
there
more
an order of contempt in Florida?
Yes, it was the order of contempt. The day before that we had the hearing, I got a message from my attorney that Shakar wanted to settle out of court. But I was prepared to go to court to go through the whole contempt phase because things were not changing.
Your Honor, can I?
Hold on just a second, please.
Okay.
Is there an actual court order? Does anybody have
Yes, yes, I have the court order via phone. I can easily send that to Jamie right here as email. I can do it right now.
Okay, well, let me just ask, was Ms. Thomas found in contempt?
No, because she settled last minute. The day
Okay,
we had court on Thursday, I got a message from my attorney Wednesday night saying that she was wanted to give me the majority of the time sharing.
Okay.
And it's also in email
okay,
as well.
all right. Is that correct, Ms. Thomas?
That's partially correct. It wasn't something, my attorney came to me and said, hey, Mr. Martell's attorney reached out and said, would you be willing to do 50-50 custody? And this will eradicate the contempt. And I just agreed to it because at that time, right now my daughter's going through a transition. So I agreed. And then the night before I spoke to my attorney, before the hearing, I spoke to my attorney and I let him know, I'm like, hey, maybe I think Zaya may need to live with her dad right now because of her behavior issues. So that was something that I told my attorney. I did not initiate trying to settle because when it came to the contempt, I don't feel as though I was in contempt wholeheartedly when it came to our order. So it wasn't me. My attorney reached out to me and said,
okay,
Mr. Martell was trying. Yeah.
So y'all resolved it in Florida. Everything's done there in terms of court orders, correct?
Correct.
Ms. Steinhaus or Mr. Martell, is that correct?
Yes, it's been resolved in Florida. Judge, I do want to note that even though I agree and we settled out in Florida, I was given more time sharing. So there's no need to go through the court proceedings. But I was prepared to go through with the contempt because she was in violations of
Okay, but there is no contempt order in Florida, correct?
No, there's not.
Okay. Just the modification resolved everything there.
Yes, Your Honor.
All right, go ahead. I'm sorry I interrupted. I just was trying to get a clarification on where things were in Florida.
Yes. So
Yes.
I think, do you have more testimony?
No, I don't have anything else other than that I would have registered, but again, they only do orientations on Mondays, so it wasn't that I would make that deadline, but I did do it.
That one. Yeah.
So it wasn't Labor Day Monday, I'm sure, right? They were closed.
Mhm.
So okay, it was a couple of weeks after the date. All right, I'm just trying to get the dates down.
Yes,
All
Your
right.
Honor.
Anything else from either side?
No, Your Honor.
Okay, go ahead, Ms. Thomas.
Mr. Martell also stated that again, I just would like to reiterate, and I have no reason to, I'm not sure where that statement is coming from, but prior to September, him wanting to utilize his first of the month visit, he had not been doing that. Again, I just want to make the record clear that we had been, prior to this incident or the incidents that we had that led up to the TPO, we had not been following our court order. Whenever my daughter would want to go with her dad, I would allow her to go with her dad. And that was just that we were not following the time sharing schedule that the court, that was with the courts for about a year and a half because he had moved to Georgia. So our order reflected us living here and him living in Florida. So we weren't following our initial court order again, but like I said, he had not utilized the first of the month visit prior to this. So it wasn't something that I just knew was going to happen. And he did go to the school on that Friday to pick Zaya up. He was picking her up early, but I was literally in the parking lot when my daughter called me and she said her dad was there to pick her up. And I said, okay, well, do you want to go with your dad? Because we were set to leave to go out of town that afternoon. And she said, no, I don't want to go. So again, I was counseled by that. I know I was in the wrong for that, leaving that to be her decision. But again, he was not utilizing first of the month visits. We were not following our court order when it came to time sharing prior to the summer.
All right. Anything in closing, Ms. Steinhaus?
I do understand that petitioner has addressed the issue with the school. I think our problem with that at this point is it was a span of months from August, September, October, and November in which he was deprived of visitation with his minor child. Again, I'm unaware of any registration with Nia's place, but I would hope that the court would enforce that provision and that subsection of the temporary protective order that was issued in August would be granted. And again, I do want to reiterate that my client has had to continue to show up to court, has continued to have to file motions for contempt in regards to visitation of his child, even though that is remedied at this point, even though Florida has a final order and it has been abided by since January. It seems like we continue to come back to court, and that's where the request for attorney's fees comes at this point.
All right. How many dates between the 12-month order and November, which I gather was when things began to open up again, but between August and November, how many dates did your client actually go to the school to pick up the child?
August, September, and October. Oh, that was August, September. That's 3 days because I see during that time before the new order, I seen her the first weekend of each month. So I would go on that Friday because the cap order told me I can pick her up from school. So I went on the Friday, the first week of August, the first week of September, and the first week of October, and I was denied time sharing because either she wasn't at school or she told the school that she couldn't come with me. Shakara told the school that I do it.
Well, we're getting into a lot of hearsay.
August wasn't a month that was violated. August, that was when we had a hearing for the TPO, so we couldn't have contact. So that was, and school had not started by the time we had gone to court in August. So there was no contact. There was no way for us to exchange. The Nia's place had not been determined yet. So August was just based on the temporary TPO, and we could not have contact. So the time that he missed was September and October only, based off of me. But when it comes to the court, the TPO came out, I believe, August 2nd, and that was his first of the month visit, and we had not communicated because of the TPO, and our child wasn't in school at that time because I think school didn't start until maybe like the 3rd or the 4th. So we didn't have time to go through Nia's place. He did not go to her school in August to pick her up for a first of the month visit. The visits he missed were September and October, and that visit in October, that was fall break. And again, we were in Florida for my uncle's funeral, and he had makeup time of 3 weeks and 2 days. And also, Nia's place does not exchange information. They, based on what they explained to me, was that they only facilitate an exchange. They don't pass messages. So if I can't come, or there's something that came up and if a child is sick, they don't exchange that information. That's what they told me. They just said they facilitate an exchange. They don't, exchange information. They only exchange the child. So he did not miss August.
Okay. What date did school start? Is your child in DeKalb County schools? I don't know.
No, she's in Clayton County, and
what date did she start school?
August 3rd.
Okay.
Your Honor?
Yes.
Mr. Martial appeared at the school on August 5th.
Okay, and what was the date of the hearing?
I believe it was
August
August
4th. I'm sorry.
I believe it was
August
2nd. I was unaware that he came to pick her up. That's something that's new to me. I know that he did come to the school in September to pick her up because we were there at the same time.
All right. Well, while the respondent has testified that the judge allegedly said that he could go the following week, there is nothing in the court order regarding August at all, other than the parties were both required to register and complete orientation by August 26th at Nia's place. The petitioner is correct. Nia's place has never been a message center at all for exchanges of messages, and I'm sorry that was in the other judge's order, because it's not, to my knowledge, in all the years I've been doing this, have been used for exchanging messages regarding visitation, other than, I guess, if somebody had car trouble and called Nia's place and said, my car broke down, I can't come, last minute type thing. But typically messages are handled either via text or email between the parties regarding issues of visitation, at least in all of my 12-month orders. That's the way we normally handle it, or the family apps that are available where parties can do that sort of thing. All right, so really we do have a situation that petitioner has admitted that she relied upon her daughter's wishes regarding the visitation, which is, in hindsight now, she understands that's not going to happen. Let me explain to both parties. I mean, y'all been handling matters in two different courts. You guys are tied together forever, and this is not a good start. Although you apparently were fairly successful, as I understand the order in Florida was several years ago at least, wasn't it? The original order. So y'all have lived under court orders. The reason we have court orders is because times occur where parties can't agree and be parents to a child, other than have a judge tell them, this is what you got to do, both of you. That applies for pickups and it applies for returns of children. So both parties have to abide by these court orders. I am going to enter a finding of contempt, and I'm going to award the amount of $750 attorney's fees, and I'm going to say that needs to be paid by April 30th, directly to Ms. Steinhouse's office. Any questions?
In the event that I'm unable to pay by then, what happens?
Well, they'll be filing another motion for contempt, and all right, Ms. Steinhouse, can you and Ms. Thomas work out a method by which this can be paid, so where we don't have to litigate that again?
Yes, I can send her various methods.
I'm sorry.
I can send her. I can make contact with her and let her know the different ways I can accept payment.
All right. Well, I guess what I'm looking at is, would you be willing to accept some installments that I can
Yes.
put in a court order now?
Are you open to that?
Yes.
Through installments? Okay. Yes.
I don't want to let y'all have to decide and not be in agreement and then be back here in front of me. So
Correct, Your Honor.
Do you wish to? Maybe we can place you and Ms. Thomas in a breakout room. And
Is there a payment date that works better for you, Ms. Thomas, than April 30th?
It would need to, Judge, I'm actually facing eviction right now, so I can just go on record and let you know that I'm not going to be able to pay that amount because a roof over me and my children's head is priority, and I'm just being 100% honest. So I would like to go on record to say that I won't be able to, I know for a fact that I won't be able to pay that amount by the 30th.
Okay, that's what she's saying. You got an opportunity here to stretch it out, is what I'm hearing.
Okay.
Does 6 months from now work for you? So that would be
little over $100 a month,
Yes. Without
Yes.
promise.
payable 6 months, beginning what date?
I mean, I would begin today and then 6 months from today.
First payment.
But I mean, I'm just saying, give her an end date, and if she wants to pay in installments, perfect. I will accept that. If she
Okay.
wants to pay in full at the end of 6 months, I will also accept that.
Okay. So just open-ended as far as the amount of payments and when that it needs to be paid off in full in 6 months from today's date.
Yes, Your Honor.
So you may be able to send $50 one time or $200 the next time to resolve this. Do you understand, Ms. Thomas?
Yes, sir.
Will you be able to do that?
I hope so.
Okay.
All right.
All right. That will conclude today's hearing, and I will produce an order and send it out shortly.
Thank you,
Well,
Your Honor.
hopefully it'll come out today. It may be tomorrow, but depending on the clerk's office. All right.
Thank you, Your Honor.
All right. Everybody have a good day.
You too.